Hello everyone. It is Tuesday, May 20th at 8:30 p.m. Eastern Time, and we are going to give our weekly update on my family law case, as well as explain the financial terrorism that I have been experiencing from the Serlick family for the last 3 years by using this illegal Illinois order that should have never happened in 2022. So last week's video ended with explaining that I filed a motion to disqualify Judge Sandra C. Upchurch, and a lot has happened since that video. So as expected, she denied it. Pete, what is the explanation of her denial for the disqualification?
It's basically just generic boilerplate. Disqualification was legally insufficient pursuant to Rule 2.330, which is of the Florida Judicial Code, basically the rules judges have to follow. Now, here's the thing. If you actually look at those rules, it literally says if there's any, even a sign that there's inappropriate behavior from the judge is required to recuse himself. And there's definitely sketchy stuff that's gone on in Heather's case. Not only is it Justin's family waving to the judge like they were best friends, somebody in the court has been feeding information to them outside of normal channels.
It's DJA, Cindy Manowski, because Mary Serlick emailed Cindy Manowski, and Cindy Manowski then filed that email into my docket. I'm not going against Mary Serlick. I'm going against my ex-husband, Justin Serlick. So what is Mary Serlick doing emailing the judicial assistant, Cindy Manowski, in my case against her son? So it's definitely leaning towards there needs to be an investigation with the JA, Cindy Manowski. So, of course, what did I do right after I got that denial? I literally turned around and in less than probably 10 minutes filed the notice of appeal. So that is, and we are now on DIN 177, guys. 177 docket identification numbers, and we're still at square one. So we're not going to be at square one much longer because we're going to be in District 5 Appellate Court soon. And I am so excited for that because it's going to streamline a lot of things because they're basing everything.
The difference with appellate court is it's very much just strict procedural.
Yep.
So they they really don't even want any hearings or testimony. They look at your brief that you file, and they look at the documents, and they make a decision. So
and when they verify whether or not laws were violated.
When they look at the document, if they do what they're supposed to, when they look at the documents, they're going to see that, in fact, the Illinois order was signed after Illinois no longer had jurisdiction to make a custodial decision.
It will, at some point, be void ab initio. It absolutely will. There's no ifs, ands, or buts about it. And I just got a great question from Rashim. Are you going to take this case to Florida Supreme Court? You better believe it. If I don't get where I need to be with the appellate court, Florida District 5 Appellate Court, I absolutely will then turn around and appeal it right to Tallahassee. And if I don't get anywhere with Tallahassee, you better believe I'm going up the food chain to U.S. Supreme Court. So, yes.
So it would be...
And this is just the tip of the iceberg, guys. This is the very beginning of a much bigger suit, because I will eventually be filing civil suits against all these players or bad actors, as you want to call them. So... Notice of appeal, that was on the motion to disqualify. So that's now an appellate court.
I do find something interesting. A lot of people who don't have experience with the court system may also find this kind of interesting. With a motion to disqualify, it goes to the judge you're trying to disqualify. So they're literally making a decision on themselves. There's no other oversight. It doesn't go to their boss. It doesn't go to HR. It doesn't go anywhere other than to the person.
But that's not how it works in all states.
No.
Because I am now learning from other victims of this family court corruption that in other states, it is not supposed to go to the judge that is hearing. It's supposed to actually go to the chief law judge. And then the chief law judge decides it based on the evidence that you're submitting. And I mean, that falls in line with Judge Stasia Warren recusing herself December 20th of 2024, right after I pulled the public records request. And her recusing herself had to go right to Chief Leah Case, Chief Law Judge Leah Case, and then Leah Case reassigned me to Upchurch. So the motion to disqualify should not. That is almost like an issue within our legal system where it should not go to the judge that is actually causing the issues. It should go above her.
There's really, if you think about it, this would be like you go into any corporate environment. If you had, let's use an example of sexual harassment. You have an employee sexually harassing other employees. Somebody files a complaint, and it goes to the harasser to decide whether or not they did anything wrong.
It goes to human resources above them.
But in the Florida
and then there's an
circuit,
investigation.
in the Florida Circuit Court system, that's literally what happens. It goes to the party that is breaking violating the rules, and they get to decide on their own fate. And the only way to get oversight on that is to do what Heather has done, which is file an appeal to get it out of the district court out of the circuit court and get it to the district court, where a panel of judges, usually 3 judges, is going to review.
However, I have now since learned, thanks to Elle, which is not her real name, that's her social media name, you know who you are, I have now learned of a different writ that I can file in appellant court to get her removed from my family law case as well. So I'll be working on that, and then I'll explain that to everyone next week. Would you ever forgive the people that are trying to hurt you and your family? Would I ever forgive them? That's a tough question. I'm going to leave it up to God. You know, their fate with what they're doing to families and God's children is in God's hands. Whether or not I forgive them has no bearing on where they go in afterlife. That is up to them and their creator. So I'm just going to leave it at that.
The unfortunate reality is a number of these players are destroying other families as well. You know, It's not that they've only come after Heather's family.
No. Upchurch alone, I have had, since my videos have been coming out,
3 or 4 other
more than that at this point. I've got like 5 or 6 people that have reached out to me privately and told me their stories about Sandra C. Upchurch as well. So it is definitely not just me with Sandra C. Upchurch in Daytona. I said it before, I'll say it again. There absolutely needs to be an investigation into these judges and administrative personnel at the Daytona, Florida courthouse. There absolutely needs to be.
Yeah.
They are absolutely violating laws and violating the privacy of their job. Coming from human resources where I'm dealing with PHI and HIPAA, we cannot talk to people outside of our workplace in regards to other people's private information. So these people feeding Mary Serlick and Laura Stiles information at the Daytona courthouse needs to be investigated, and criminal charges need to be brought against them. And I keep saying it, but I absolutely will be at some point talking to the state attorney's office and inspector general. And then after the notice of appeal was just the, once again, application for determination of indigent status because I am broke.
Yeah. And that basically you have to file every time, because if you have money, then you have to file, there's fees to file everything.
So like this right here. So DIN 180 is a letter from the Court of Appeals, so District 5 Court of Appeals, telling me that upon consideration that the motion to vacate appears to have been timely filed from the order being appealed, and as such, this appeal should have been held in abeyance pursuant to Florida Rule of Appellate Court. And basically, they are saying that they're merging my notice of appeals together, which is what I want them to do. So awesome. And then on my notice of appeal on the motion to disqualify that she denied. I then got acknowledgement of new case from the appellate court. So we're now on DIN 182. And basically, and then right here it says filing fee $300 waived. That's the indigent status. Those fees are being automatically waived as soon as they approve the indigent status form. So any of you, if you need to get into appellant court, just know that if you meet the criteria for indigent status, you can get all these appellant court fees, including the index fees, waived through the appellant court, as long as you qualify for that indigent status. So all of that is waived. So the state of Florida is waiving all the fees. I don't have to pay anything because I'm indigent. So acknowledgement of new case. So I've now got 2 different case numbers in the District 5 Appellant Court, and I want the motion for disqualification to stay its own case.
And we have reasons for that, but we won't discuss them on this video.
Yeah, I'm not giving away my strategy to certain people, but you'll see why I'm keeping it as 2 separate cases. And then DIN 183 is my directions to the clerk. So obviously every time you file a notice of appeal, you have to file a directions to the clerk within 10 days, telling them what you want to include into the appellant case. Otherwise, they will do the bare minimum. Obviously, I want my entire docket in the appellant court because my entire docket, 1 through...
tells a story.
I think we're at 189 now. Tells a very telling story of the illegal activity in my case and everyone violating my constitutional rights. So if I have everything included in the docket to appellant court, if I don't get where I need to be in appellant court and I move it to Florida Supreme Court, that means that all of those documents will follow to Supreme Court. So it just makes everything easier further down the road because I'm thinking much bigger case and I have been the whole last 5 years. And then DIN 184 is a motion to stay child support pending appeal. So Pete, this is the entire, so this right here is one motion with a ton of evidence. Mm-hmm. So this is just one motion right here. And this is DIN 184. Explain to everyone why I'm doing this.
Okay. So back in November, there were basically what's happened with Heather's case here in Florida. Heather filed a case in Florida to reestablish her time and connection with her children. Instead of working with Heather and coming up with something reasonable to allow Heather to see the kids, Justin went out, got an attorney, and instead of working, they strung us and our attorneys along for a while until ultimately, when Heather's attorneys started filing to get things moving, they filed a motion for contempt.
And that was Rick Brown in Daytona.
Because Heather has not been paying child support. Now, there's a number of reasons for not paying child support, aside from the fact that she didn't have funds.
Aside from the fact that he is holding my children hostage.
Okay.
And I have that in an email where he said that to my first attorney, Mary Jane Nettles. Yeah. She can see the children when she pays me child support. So, it's not how it works.
So basically, everything stopped, and we had to go through this whole contempt process. In the contempt process, for contempt of child support or willful contempt, you have to have the ability, like the actual Florida statutes say, the person has to have the ability to pay. You can't hold somebody in contempt if they don't have the ability to pay. Well, when you have geriatric old judges that had already retired but get brought back.
She turns 75 in less than a month.
She's going into forced retirement now.
75 years old.
But, back in November, it's apparent that she just signs whatever gets put on her desk. So Justin's attorney filed a proposed order which included the original child support amount, but also added $1,000 arrearage payment due every month. And right after the judge signed that, Heather gets an email from the assistant at Justin's attorney's law firm saying, hey, can you send us a different copy of that financial affidavit? We can't access it. We can't read it. So they literally admitted, and we have the email documents, that they did not review the financials at all, which they're required to do, you know,
It's the
and
law.
then they just dumped something on the judge's desk, which she signed. And
She signed it within an hour. If you look at the timestamps of when Serena Baldacchino of Rice Law Firm emailed, well, I shouldn't say Serena, it was Paige Russo, her paralegal, emailed the proposed order to, it would have been Division 35, Estasia Warren, Division 35. I got CC'd on that. I immediately responded with, I do not agree to this proposed order. It's nowhere close to where my financials are at. Within an hour, I get an email with the actual signed order. So she signed it almost immediately.
Anyways, we filed this, or Heather filed this motion to stay child support pending the appeal, because Heather has appealed a number of things with this case, and our argument is, and this is what we'll be presenting to the appellate court, is that the Illinois court that issued the original child support order did not have jurisdiction to issue the order that they signed in April of 2022, which was a custody order.
Well, it's not even really that. It's just order.
Yeah, it was a 2 or 3 page document that just very broadly gave Justin 100% parenting time, 100% decision making, and the statement relating to Heather says it's, you know, the court reserves as to any decision on Heather's time. Not that, you know, Heather's rights were ever terminated. In fact, I dare, you know, anybody to find any filed court documents that ever terminated Heather's parental rights.
They don't
exist.
They don't exist.
So anyways, because
the only
the appeal
reason
is going on,
I don't have my children in my life is their father, Justin Serlick.
Because the appeal
There is nothing keeping me from my kids.
Because the appeal is going on, and it's our, you know, belief that if the appellate court does the right thing, once they deem that the Illinois order was, you know, issued without them having jurisdiction, that order becomes null and void from the moment it was signed, which means none of this child support exists.
Right. And it's the $785 a month that is ordered in the Illinois order from 2022 is not even based on his financial affidavit or my financial affidavit.
As best we can tell.
We know exactly what the $785 is based on. It's expenditures listed on his financial affidavit.
That was the only
he
thing
is
that came up with
claiming
that
that he is spending, and I would love to have my own children verify this someday, but he is claiming that he is spending $400 a month on my children for entertainment. Meaning he must be taking them to Disney and all sorts of really cool things.
Well, no, that's
all the time. If he's spending $400 a month in entertainment,
that's like one person at Disney for half a day.
Well, you got my point. Yeah. Because what I'm getting from my children is they don't go anywhere or do anything except sit in their house and play video games. My youngest son literally told me he doesn't even know how to swim. So that's Charlie right there. He's 8 and in 2nd grade, and he literally told me last year he doesn't even know how to swim. So what is he spending $400 a month in expenditures on? He's not. It's a fictitious number that I have not gotten a single receipt on yet. Right. So until you start coughing up receipts, not going to be coughing up any sort of money. So this is not. You're going to withhold my children from me and hold them hostage while you bleed money from me. This is not how this works. So, of course, what do you think happened as soon as I filed that motion to stay child support? Take a wild guess.
Well, it bounced around through a couple people at the court, but it's interesting when you follow the trail of forwards.
DIN 185 was sent to an HO, Child Support Hearing Officer, and that person is Neil Kaufman. And then Neil Kaufman is supposed to be the one reviewing these. But his name is not on this. So it's interesting that I'm being told how it should happen, but it's not actually happening that way. So, of course,
it circles right back to Judge Upchurch and denied.
Denied. And what is the reason it's denied, Pete?
There's supposed to be a reason?
There's supposed to be a reason.
Because there's not.
Yeah. No. There's absolutely supposed to be. If I have to quote Florida statutes to them, they have to quote Florida statutes back to me. That's how this works. And you don't have to have a JD to know that.
Yeah, it literally just says, ordered in a judge that the petitioner's motion to stay child support pending appeal is denied. No explanation. It doesn't say it was legally insufficient. It doesn't say there's no provision in the law for it. Because we put in the order, and when Heather posted online, there's a lot of case law and case history where the courts have issued stays for child support, especially when one party has no ability to pay the amount. They courts issue stays somewhat regularly.
But yeah, there was that slap of denial, just like
denied.
I expected. I knew it was going to happen, which is why literally 5 minutes later, so when was this time stamped? 4:45. So literally not even 2 hours later, I've already got my notice of appeal filed and ready to go to send this over to Florida District 5.
If anybody out there is wondering how Heather's able to respond so quickly to this stuff, it's two things going on. One, Heather has signed up for e-services, so she gets emails as soon as the stuff gets into the system. So it's important, anybody out there, if you're going through this, you need to be on e-services. Don't wait to get stuff in the regular U.S.
you've got
mail.
Deadlines.
You will miss stuff, and they don't always actually put everything in the regular mail. The other thing is, the reality is this has turned into a full-time job. Just to be able to not only respond to the stuff, but you're having to literally learn.
If I had a normal 9-to-5 job, like I've had most of my life in human resources, where the problem in Florida is they give judges wide discretion, they cannot deny with info. So if I had my normal 9-to-5 human resources job where I clock in, I get on the phone, and I'm on the phone for 8 hours straight, and I'm just talking away, and I can't step away for even a minute, there's no way I could do any of this. There's no way.
Because it's not a matter of just responding and getting a document prepared here and there. It's literally every time you're doing something, you are having to learn new legal procedures.
We're teaching ourselves stuff. And Elle knows exactly what I'm talking about. She's self-teaching herself right now, too. So the very next thing was that appeal. And another indigent form. Because every time you file that appeal...
Here's the thing. It's... The court, think about the logic here. The court is acknowledging that Heather doesn't have money to be able to pay the filing fees. But then when Heather's trying to modify the child support to get it to something that she could pay, the court's just flat out denying it.
Yeah. So. And then we spend hours. I know I'm not the only one that complains about this with all the people I've been connecting with across the country. But we will spend hours putting these motions together, and in a split second, the judge just rubber stamps a denial. And I don't even think it's the judge, honestly. I think it's the JA stamping the rubber stamp of denial. Yeah. And I'm curious to know if Upchurch even looks at any of this. That would be a great question to get answered in an investigation. So then, explain this before we get into this next motion.
Okay.
So use these forms.
Okay. At some point, so here in the state of Florida and a lot of states, whenever a party in a child support or family court issue files to receive state services like Medicaid, that instantly brings the Florida Department of Revenue in as a party to the case, because child support is collected and enforced through the Department of Revenue. Now, the Department of Revenue has several tools available to them. This is by state statute. This is what the laws are. So a lot of this is just automatic. It's not something that Justin has or his family has necessarily filed, other than the fact that they got this contempt order for child support through the court.
Well,
it's been kicked over to the Department of Revenue.
Justin definitely filed something with the Department of Revenue because about a year ago I got a letter from them and it was reversed. Justin was the petitioner and I was the respondent. And then it was listing my family case number as the 13D981. That is my Illinois divorce. So Justin is actually screwing up the Department of Revenue child support case by not filing it properly.
It was first filed with the Department of Revenue back when Mary Jane was still your attorney, because we took it to her and asked her to explain it and or help figure out what we need to do with it. And even she looked at it and was like, well, this doesn't make any sense because
he's
literally
not the petitioner. You are.
Everything was wrong about it.
Right.
But anyways, what we got, or what Heather received, was basically it's a generic, automatically generated form letter, just notifying her that the Department of Revenue may file with the Florida Department of Highway Safety Motor Vehicles to suspend Heather's driver's license.
They're trying to take my driver's license and my registration.
It's and I understand there's a reason for the law. The reason for the law is because there are people out there that have the means to pay child support and refuse, and you have to have some way to hold them accountable. I understand that, but the reality is, in Heather's situation. And I say this because I've seen her bank accounts. She lives with me. I know what I'm paying for. I know what her income has been for the last 2 to 3 years.
Most of last year, I couldn't work, even if I wanted to. I was in a really severe car accident April 15th of 2024. I had a Corvette rear end me at a stoplight while I was driving Pete's car last year. And that Corvette rear-ended me at 45 miles an hour and ended up underneath Pete's car. It shoved me 2 cars in front of me.
It hit Heather at full speed, forced my car into the car in front of Heather, and then forced that car into the car in front of it.
So I was in treatment until the end of last year.
And then you're still having issues.
Yeah, I am still having pinched nerve issues in my shoulder and everything. So it's not even a matter of I don't want to work. It was a matter of I could not work last year. I was in and out of physical therapy 3-4 times a week for most of 2024. I couldn't even, when we went to Chicago last July to deal with my children and I's property, I wanted to go to Six Flags. I couldn't because I was literally only 3-4 months into treatment for 3 bulging discs and 2 herniated discs in my spine from the car accident. So, it's just absurd that this level of financial terrorism at this point is occurring.
What happens is, again, the logic here, if they do suspend Heather's driver's license, that pretty much blocks her ability to have any other outside earnings. This is literally
they're forcing me to become a prisoner.
Heather calls it financial terrorism, and to some extent it really is, because here's the thing. We fully understand the reason for the law to exist, but when you go through all of this information you get from the Department of Revenue talks about, if you don't have the ability to pay, file stuff to and you get get things modified. Heather, when's the first time you filed to modify child support? Back in November is when you filed the first time.
November 21st, I filed a petition for modification of the child support, which triggered in my docket a summons for Justin. He was served by the sheriff's office to produce his financial affidavit, because in the state of Florida, you have to have both financial affidavits to do the child support worksheet to complete the modification. Yeah. Well, this court between Judge Warren and Judge Upchurch
completely ignored
completely ignoring
didn't compel him to file his financial affidavit.
So he's actually in contempt of court.
This was actually the second notice to comply, because Heather's second attorney, Rick Brown, he filed motions to modify this, where Justin was supposed to produce financial information, and Justin and his attorneys never responded to any of that.
They're literally ignoring everything.
And so anyways, we got the form letter from the Department of Revenue, so we're following the steps in that to respond to it. And one of the things, so they tell you have to file with the court to contest anything or to modify. So this is threatening to suspend her license, so Heather has filed one of the options you can do is file a petition. File a petition with the court. And
to contest, you must file a petition with the circuit court and then send a copy of the petition to the child support program in Tallahassee. So right now, what do you think I did?
Right now, Heather has two different things, going through the court and the child support, and that is, Heather's contesting them suspending her license, but then she's also gone through the Department of Revenue to modify the child support.
So they actually sent me a letter a while ago. It was back in April, telling me your right to a child support review. So I called Tallahassee, the call center. They said they were going to send me a packet, never got it. So I called back again, and they're like, oh, we show it was sent the next day. Well, I get everything else from you guys. Never got that. Go figure.
Yeah, how many letters have we gotten from
the Department of Revenue? So they told me, I wish they would have just told me this when I called back in April. They're like, oh, yeah, you can just go to the child support office for the Florida Department of Revenue in Daytona. Great. So I went right there. I triggered the child support modification review packet to be done. I filled it out. I dropped it off. I mailed Justin Serlick a copy of it. And so that's happening in the background. So obviously, I'm going to fight tooth and nail before this BS from the 2022 Illinois order that should have never happened takes my driver's license. It makes me a prisoner in my own home. But so I filed a verified motion to contest driver's license and motor vehicle registration suspension, and then put in all the exact same exhibits that was in my motion to stay child support. That was already denied.
And literally, like what she's including is her financial affidavit.
And then the copy of the financial affidavit I filed back in November, showing history of this.
The only thing that's not in here is copies of her actual account statements, but those we have available. They're not required to submit with the actual financial.
So that verified motion to contest, that's how thick that motion is, with all the exact same stuff as the motion to stay child support. So that's in there. And then the very last thing is, yet again, another indigency form. So whenever you see at the top where it's crossed out, this is when you go to file the notice of appeal, and for the options for payment, you have to put in the indigent form. Well, when they review it, they cross this out at the top and then right at the bottom what they are waiving. So this is the appeal fee of $100. So these end up popping up constantly in my docket because you have to file it with the notice of appeal
every single time
to get that $100
and
fee.
That's because you could be indigent today and then win the lottery tomorrow, and then
or you can be indigent last week and now all of a sudden you've got a job. And if you're trying to be truthful, because it's basically saying if we find that you're not being truthful, we will hold you in contempt and you can be arrested. There's actually a little thing at the bottom that says applicants found not to be indigent may seek review by a judge. There's no fee for this review. So that's if they deny it. But yeah, if they find out that you're lying on these forms, that's criminal. So of course I could be held up to criminal standards, but not the judge that's doing this.
Literally, the reality of Heather's financial situation, and it's unfortunate. This happens, to a lot of people in family court. That first the attorneys take all of the money they can, and then then you're left with nothing. You lose your job because you have to take time off. I mean, that literally happened to Heather with her last job. She had got a new job. She was excited about it. And then that first week, the judge schedules a hearing in person at court in Daytona. Heather requested time off, and they said, well, you're still on probation, so we're just going to let you go now.
Yep.
And you just get into more and more of a financial hole. The reality is, if Heather and I were not together, and Heather was on her own completely, she'd be on the street. Which
is why Mary Serlick and Laura Stiles are going to great lengths to destroy our relationship. And are they succeeding?
No.
No.
Suck it.
Sorry. All right. So that's it for tonight, guys. So yeah, I'm totally expecting a denial of the motion contesting the driver's license, and then of course that will immediately get a notice of appeal as well.
The only good thing right now,
moving along in appellate court.
Right now, we've got some contingency plans in place, but it's gonna definitely create some hardships that are really unnecessary, and they're only going to exacerbate the situation even worse. And the reality is that's Justin and his family's goal. Whether Justin's actually aware of what's going on or even cares, who knows?
How did he look at the most recent court hearing?
Physically, he looks terrible, and it was funny. So I know we wanted to cut this off, but last night you had pulled up some videos on your phone of back when
like
you
2017,
were still living
2018,
with him.
2019 era,
and compare that person in those older videos to the person I witnessed in court. You have to wonder why he's continuing, because really, ultimately, this is him. He's doing this to himself.
Yep.
He can turn around tomorrow and say, "Okay, Heather, you want to see the kids? Come see the kids. You can come pick them up." Or, Heather, you want to see the kids? Meet me at the police station, and you can have them for the afternoon. And we get some time with the kids. Heather sees her kids. We drop them back off at the police station, or drop them off, down the street from the house, whatever.
But see, they can't do that. And why can't they do that? Because then that means that Justin, Mary, and Ira have to actually tell my children the truth. And they are too buried in their own lies and their fantasy world that they have created to surround my children in, that in order to explain to my children, all of a sudden, poof, they're seeing their mother in their life, they would have to actually explain to my 4 children, Ariana, Tommy, Bianca, and Charlie, that they have been lied to for the last 5 years by them. Yeah. And they are clinging to those lies. Yeah. And that's what these videos are. These videos are to expose the real truth behind what is happening. These videos are for my children to watch someday, if not now, and really see who the actual instigator of all of this is. This is all happening just because I want my children in my life. This is all happening.
You want your children in your life, and you don't want Justin in your life.
I am fighting for my children. And there's only so long they're going to be able to keep up this lie before it comes crumbling down. So I don't know. Guys. You tell me. I'm putting this out to the masses so I can get a internet jury. So I want the internet jury to tell me what's actually going on here and explain what's actually going on here, because once we get into appellate court and Supreme Court, they're going to look at the documents that I've been filing. They're going to look at the timing. They're going to look at that Illinois order, realize that it's void ab initio, and they're going to be like, okay, well, Mom's been trying to do this all the right way, and you guys are the ones doing illegal activity, blocking her, denying everything. So who's really losing here and who's really winning?
Yeah.
I mean, it's
the civil,
a game of chess.
The civil suit that's going to come after that is here's the thing I would say. Anybody out there, and I say anybody because we know there's certain people that are going to watch this and try to pick this apart. Look up to see what happens when people violate the UCCJEA, and see what happens when the courts say, "Oh no, this violated UCCJEA." Have at it. Take them to civil court. See what happens. Look those up.
Nurheim, I'm coming for you.
Yeah, for some of this stuff, there's no judicial immunity, and certainly there's no immunity for other parties that got their attorneys to file stuff that violated the UCCJEA. That motion has Heather. Well. It was signed by the judge, but the evidence that was put forth to get the court to sign it was signed by Justin as well. So he's liable, and there's hell is coming, and that's what we'll leave it at that. Hell is coming for some people.
Yep.
So.
Have a great rest of your week, everyone. I will go live with another update next week. I was really trying to keep this on Sundays, but I've been kind of busy.
I think we're going to have a surprise. We're going to do a fun video on the next live. So.
All right, guys. Have a great night. Thank you for listening, and I really appreciate you guys. Hang in there. We'll get through it. I promise everyone. We will get through this together as victims of this family court corruption. Bye.